cooperative, just didn't come here today because she's afraid of the defendant.
Your Honor, if I may just gain clarification from Ms. Leone, the victim that you're referencing is the victim in the felony cases?
Yes.
Okay.
Yes, yes, yes.
So it's another subsequent thing, subsequent case that the victim.
I believe he's referring to the misdemeanor case victim who
Okay.
may be. Now, I do have information even about that from the misdemeanor case that she has moved. She is afraid of the defendant. That's the reason why she
just
said that
read
she
the
wouldn't
letter?
cooperate, but not because it didn't happen. Additionally, the victim in our felony case is aware of multiple arguments and fights between this defendant and the victim in the misdemeanor case. The evidence in our case for possession of weapon by convicted felon is very, very strong because he was actually seen with a weapon in his hands by law
Let me ask
enforcement.
you this, what is he looking at if he gets
Yes, sir.
convicted?
Yes, Your Honor.
If he gets convicted?
So he scores a minimum of 20 months DOC, facing a 3-year minimum mandatory.
Oh,
And-
if it's a minimum mandatory, I'm gonna leave the bond revoked. or-
Thank you.
Thank you. All right.
Your Honor, procedurally, with respect to Ryan Williams, is that matter set for the next pretrial? Do you know?
Yes, it
Okay,
is.
all right. That's good. Well, Jennifer Flowers, just-
Madam Clerk, could you verify, please, is set for next pretrial 6/24? So we can set it for 6/24, please. Thank you.
And this is Haley Bryant.
Yes, Judge. Haley Bryant's before the court on 21 CF 2922. It appears Ms. Flowers was just appointed on this case last week. We would ask to move this to 5/28 to see if we can come to a resolution.
All right, May 28th, thank you.
Bring it back.
Let me ask something
Christy
real
Hawley?
quick. If there is anyone here for any sentencing, I think they are going to be at 2 o'clock. Is anyone here for sentencing on Philip Lee case? No? Okay. Yep, Mr. Keith. Pardon? What am I sentencing you to? What do you want, probation or county or DOC?
For me, I just take a prosecution.
You don't qualify.
Your Honor, may I address
You have
one
to
more
be
case?
spotless to get a deferred, huh?
I apologize. May I address one more case, Judge?
Okay, go ahead.
It's actually on the 2 o'clock afternoon docket. Samuel Mosley,
Yeah, what about that one?
16 CF 2013. I'm going to ask for one last continuance. I think the state might be okay with that. We're pushing the boundaries of how long we can drag this out, but I think this will be the last continuance.
Your Honor, as Mr. Mosley is date for that, and I have to make sure.
All right, we'll tentatively set him for when?
After miscellaneous docket, if that's available.
Sometime in June, Judge?
What about June 27th? How about that?
That should work, Your Honor.
That's fine, Judge.
Let me, Steve, would you text Cheryl and say Mosley got continued so we don't have our staff?
Yes.
For who?
This is Christy Hawley, 23 CF 1405 and 21 CF 3096. Judge, on Ms. Hawley's case, Ms. Flowers was appointed last week, so we would ask to move this to 5/28. She can receive discovery and go over the case with her client.
Okay, 5/28, thank you.
And apparently, Judge, I do have one more.
Judge, that's right. There's Shane Bell. He's on the 2 2 o'clock docket. He was scheduled for a child hearsay motion and a motion to sever this afternoon. Ms. Flowers called me yesterday afternoon. She's not feeling well and won't be present today, so we would ask to move that to June 6th.
Which one was that?
Jane Bell, 1878.
Was that set for 1:30? 2? Oh, fell. I thought you said foul. Okay. All right, so we'll set him for when?
We asked to set him on June 6th in the afternoon docket.
Okay, June 6th. Right
Judge,
now, yeah.
the court has pretrial detention hearings at 12:30 today.
Yeah.
Ms. Flowers is asking to appear by Zoom. I also have pretrial detention hearings down south, which is why I can't cover for her, but she's asking if she can appear by Zoom for the 12:30 hearing, Judge, if possible.
Sure.
Thank you, Judge. That's all I have this morning.
Okay, thank you. Yes,
I didn't add my name to the list, but.
is it, yeah, come on up if you're ready. It says you're representing Matthew Stevens?
Yes.
Okay, go ahead.
2021 CF 948. And we did file a motion for early term of probation. This was originally an executive assignment assigned to out of the state attorney's office in Leon County. I did speak with Ms. Bossell this morning, because even though I reached out to Leon County, nobody responded to me. So if somebody has to step in for the state, she agreed that she would stand up. We did file a motion for early term of probation. Mr. Stevens was originally sentenced to 24 months in the Department of Corrections, followed by 30 months of probation. He served the DOC sentence, has been on probation for 18 months, has approximately 12 months left. I do have a letter from his probation officer. She was unavailable to be here today, that he has completed his sex offender treatment at Cordova Counseling. He is current. When I spoke with her last week, he had not paid for May. I do have a receipt that he has paid for the May cost of supervision. He's paid all court costs. He's complied with all conditions of his supervision, reports monthly, and complies with all instructions given to him. Being on probation is limiting his ability to be a productive member of society based on where he is living and not being able to obtain a good job based on the terms of the probation. He still will be a registered sex offender, which will still have the monitoring on him and rules to comply with, but it's the probation. He does have the promise of a job. He's has to be able to use the computer and write reports. He's not allowed to have an email address right now, which is limiting his ability to have that, as well as initially, when he was sentenced, he believed that when he got out, he could live with his parents. His probation officer, when he got out, told him he had to move from his parents' house, so he does not have stable housing right now, would like to be able to move back in with his parents. And so we're asking that the court terminate his probation based on all of that.
How much time did he do in prison?
24 months. I think he did 20 months total. He was sentenced to 24 months.
What does the state say?
Your Honor, due to the nature of the charges and the fact that he has shown an interest in
Been on probation 18 months after prison?
Yes,
Got 12 to go?
yes.
Is a probation, is it out of a, how come it's here? I mean, how come who's the probation officer?
Michaela Shelton?
Well, Mr. Barry, what?
He's being supervised down in the south end of the county, and that is his probation officer.
Oh,
He
okay.
hasn't reached out to me to give me any information about this case, so unfortunately, I apologize.
Your Honor, we have reviewed the email that Ms. provided that he has actually completed everything.
Probation terminated, thank you.
Thank you.
Send me an order.
What? Yes, sir. That's all I have. May I be excused? Thank you.
Mr., let's see, Mr. Stewart?
Morning, Your Honor.
Morning.
May it please the Court, Your Honor, Brad Stewart, on behalf of Jordan Harris, Judge. This is 22 CF 2431, Jordan Harris. Judge, we're before the Court with regards to our request to amend the bond conditions, specifically as it relates to contact with his minor child. Judge, back in August of 23, the Court entered a supervised contact order, specifically allowing him contact and following the DCF case plan. That was supervised contact generally. The case plan called for once a week supervised contact. He has worked the DCF case plan. That dependency case is now closed. DCF is no longer involved, which necessitates our presence here before the Court so we can modify that. He has completed and complied with the plan in totality without issue for 2 years. We're asking for unsupervised contact with the minor child, or in the alternative, for supervised contact with his parents. His parents are present here in the Court. They have dedicated themselves and invested themselves in Mr. Harris's life as well as his minor child, their grandchild's life. We think that is a prudent approach to contact in this particular case, Judge.
What does the state say?
Judge, this is an aggravated child abuse case. This is an 8-week-old baby with a broken femur. She is now nearly 2 years old, but of course she has reproductive capacities of her own. As Mr. Stewart mentioned, state agreed to having supervised contact with DCF or FFN or their personnel present in the room in 2023. We would ask that contact be supervised either by the mother or the mother's mother or at Safe Connections. On May 6th, Judge Okaloosa in the dependency case in the minute sheet noted the defendant is allowed supervised contact, supervised by mother, mother's mother, or at Safe Connections. We're asking for that same contact provision in the criminal case. I understand Mr. Stewart's request, but we do have concerns that the defendant's parents are obviously aligned with the defendant and would not be sufficiently protective over the baby as supervisors.
The defendant's parents are what?
Aligned with the defendant.
Oh, aligned. Okay.
So that they would not be sufficient supervised contact.
I mean, how long, is he on probation now?
No, Judge, the case is still pending. We have depositions set in June. We adamantly dispute the allegations as alleged by the state judge. We anticipate this to be a heavily laden medical situation.
Well, since it's not resolved yet, I'll allow modification with supervised, add his parents to those other ones that can supervise.
Okay.
That should provide flexibility. I mean, I'll allow both his parents, one or the other or both. And, you know, if it was, we'll just have to wait and see how the case works out.
Yes, sir.
But at this point, if he hasn't, that's not been figured out yet, he still needs to be supervised to some extent, that I think.
And just to be clear, Judge, that would be who is going to be his future ex-wife. That was our concern about only allowing the wife or maternal grandmother, as well as both of his parents, allow for supervised visitation.
So I'm adding either one of his parents to that list.
Yes, Your Honor. Okay.
Y'all gonna supervise? Okay. All right, so send me an order on that.
Yes, Your Honor.
Okay, thank you.
Your Honor, my next case is Mr. John Harvard. And for the record, this is Brad Stewart on behalf of John Russell Harvard, Judge. This is 22 CF 1810. Judge, we're before the court with regards to our request to modify probation. As Mr. Judge, would it be okay if Mr. Harvard stands there? He's got some medical conditions. That is the basis of our request to modify probation. Judge, on February the 8th, we modified his probation to 2 years of community control, and he cannot be within 1,000 feet of the victim's residence. The problem that poses is that doesn't allow him to return to his particular residence. We were able to achieve a different place for him to live. However, that was in a house trailer. That house trailer apparently has spotty water and electrical service. Mr. Harvard, as the court can see, just recently underwent a surgical procedure. He also has liver cancer. He has to make routine trips to the doctor, and it is problematic for him to care for himself. In order for him to achieve proper cleanliness, hygiene, and care for himself, we're requesting that he be allowed to return to his home at the Spruce Lane address for where he lived at prior to this incident, Judge. That's our request.
How far away is it from the victim's house?
Judge, we previously had 500, he cannot go within 500 feet of the victim's house, which was sufficient. However, the underlying order also said he cannot live there. So we need to actually vacate the order, special condition of him not being able to live at that residence and go back to not within 500 feet of the victim's residence. There's also a different ingress-egress that he can go around, so he doesn't have to go by the victim's property at all in order to get there.
What does the state say?
Ms. Hillard, the victim in the case, is here, and she would like to make a statement to the court to describe what the situation is and how she feels about it.
Judge, I would object. She's not the listed victim. It was her husband, and I think her husband was only listed in interlineations. It was written in the information. It was actually a store clerk that was listed as the victim.
What does that mean, store clerk? I
Yep.
don't understand.
That she was not the victim. That's my point. That's my objection.
He committed aggravated assault with the firearm against Ms. Hillard's husband. And
Where's he at?
Not here.
Where's Miss Hillard's husband?
Ms. Hillard is here. She was present during a battery that occurred between the defendant and her husband. So she witnessed that.
Where's the husband at?
Your Honor, this was such a short notice, he was not able to get off work, but I do have a signed statement now from him.
Okay, let Miss Leon see it and Mr. Stewart. Mr. Nopes, are you ready to go?
Judge, I'm not, I need to speak to my client real quick.
Okay.
Can Ms. Hillard read this?
I'll let the judge read it.
Your Honor, may she address the court?
I can read it if that's all right with her, or she wants to talk and read it.
I would prefer to read it.
All right, come on up then.
And Your Honor, this is Ms. Hall. She's our victim advocate.
I know, Miss Hall.
Your Honor, I'm here on behalf of my husband and my family as well.
Okay, and let me, just for the record, your name, please.
My name is Brandy Hillard.
Brandy Hillard?
Yes, sir.
Okay, thank you, Miss Hillard.
The defendant was staying with his girlfriend, who is my neighbor, on her property at the dead end of Spruce Lane. And on July the 15th, 2022, he pursued my husband that morning at my mother's house, who was also living across the street from us on Spruce Lane. Later that day, the defendant followed my husband, ultimately pulling a loaded gun on him while inside a convenience store, and this was caught on video camera at the store. Afterwards, the defendant continued his uncontrollable behaviors when he struck my husband in front of our home. I still to this day do not know why he targeted my family and chose to endanger the lives of those people at the convenience store. His attorney stated in court around December 6, 2022, during a bond hearing, that the defendant's medical condition and a change in his medication contributed to, from his perspective, what occurred that day. My greatest concern today is what will be his excuse for his actions going forward now that he claims that his condition is worse. Unfortunately, my husband and I have medical conditions as well, and I can sympathize with this situation. However, he had no regard for my family or the community on July the 15th, 2022, and he's shown no remorse for his actions. There's no excuse for what he did to my husband and the folks at that convenience store, and my fear of what he could do if given an opportunity is a very real fear for me and my family. On September the 5th, 2023, he was given a generous offer of standard reporting probation. As soon as he was out of jail that day, he was next door to us on Spruce Lane, going up and down the road and standing at the end of the lane. In only 4 months from his release, he violated his probation and was arrested on January the 10th, 2024. And yet again, he was given a generous opportunity for probation. All the while, he stood here in this courtroom, sticking out his tongue at your camera on February the 8th, 2024. He freely and voluntarily entered into probation agreement, and today, only 3 months later, he is before you to ask you for leniency again with his alleged medical condition as a basis for his request. His attorney also stated on December 6, 2022, that the defendant has a long history in the area with significant ties to the community. He comes from a pioneering family who owns real properties, and he owns his own home. If that's true, Your Honor, then there's no reason for him to be within 1,000 feet of my home and my family under any circumstances. This distance covers my property and my family that reside next to me. The only reason he would make that request to change his probation is so he could stay with his girlfriend on her property next door to my husband and I. This is a dead-end road, so he would have to pass directly in front of my house.
Hang on 1 second. This is not Mr. Harvard's property, this is his girlfriend's property?
That's correct.
Judge, that's correct. That's, the basis there is he needs medical care.
Denied, thank you.
Yeah.
Thank you,
Thank you, Your Honor.
Judge, that's all I have before the court. May I be excused?
thank you. Mr. Keach? Is it Terrell? James
Yes, Your
Terrell?
Honor.
Okay.
Good morning, Your Honor. Laura Battaglia, Assistant Region Counsel with the Department of Children and Families.
How do you spell your last name?
B as in boy, A-T-T-A-G-L-I-A.
Oh, Battaglia, okay.
Sir. Your Honor, the department had filed a motion to intervene and to vacate the commitment order in this matter. Mr. Terrell was previously committed to Florida State Hospital. And if you would like me to expound on the motion, I believe that possibly Mr. Keach and the state, we have.
All right, okay, I remember this. Go ahead. Is there an agreement, Mr. Keach?
Well, Judge, if the court may recall, he was found incompetent to proceed, and Dr. McDonald recommended services to be either provided at the jail or conditional release. Right. The state moved to have him placed with the department and the state hospital. Based on the court granted that, and that triggered your motion to intervene. So, you know, at this point, I think maybe what would be appropriate is a second evaluation to be done on Mr. Terrell to have corroborating evidence as to what would be the best restoration practice if he is still found incompetent.
What do you say, Ms. Battaglia?
Your Honor, the department is not objecting to a second evaluation. I think the biggest issue in this is that the evaluation was the sole evidence that the court relied upon to enter the commitment order, and there was no recommendation that Mr. Terrell met criteria under statute under Chapter 916. So there was no indication that he was a danger to himself or others that would bump him up to a more restrictive level at Florida State Hospital. So we do not object to that second evaluation.
Ms. Basso? All right. Well, send me an order. Okay.
Thank you.
All right.
All right.
Okay, thank you.
Thank you, Your Honor.
For control purposes, do we want to set it on June? I mean, the evaluation won't be done by June 24th.
No, it won't. So we'll say, we'll try July 25th. How about that?
All right. Thank you, Your Honor.
Okay.
Thank you.
Mr. Nopes is ready.
I've got one case on the docket, Lee and Talbot.
All right.
But I was hoping we could resolve it today, but unfortunately, we're not going to be able to. We're going to ask to put it on June 24th.
All right. June 20, continuance to June 24th. Is there any objection?
Yeah, for pretrial.
Yeah, just for the record, that offer, Mr. Nopes, that I just made this morning will only be open until the 24th, then I'll revoke it.
Understand.
All right, if you get it resolved, move it up. Thank you.
Thank you, Judge.
We still got these trials going to go, supposedly?
At the end of the docket.
Pardon?
I think we have a few that were left on today, Judge, so if we could all at the end of the docket to figure out.
Okay.
Your Honor, I have some out of custody.
All right.
Judge, the first one I'd like to call actually is not on docket. It's Miss Courtney Ard. She is here. She was supposed to be here on Monday. We were asking to recall the capias.
She's supposed to be here Monday.
She was supposed to be here Monday, Judge.
Why wasn't she here Monday?
Why weren't you here Monday?
Monday, sir, I apologize. I was supposed to be here, I thought, on the 9th, and I did not know it was the 6th. So it was a mix-up of dyslexia, and it's not an excuse.
Dyslexia?
Dyslexia, Judge.
Dyslexia?
Case numbers are 23 CF 862, 23 CF 863.
What's she charged with?
Judge, she has two theft and burglary charges in these stemming from allegedly using a debit card or credit card that belonged to another person. The offer that we last had did not call for any incarceration. It called for supervision. We were working on getting depositions set as well.
An offer of no incarceration.
Correct.
And it's an older case, Your Honor. I extended that offer for a plea, but then
Few
she
months
failed
ago,
to appear, and I intend on going forward on the failure to appear, even if the warrant is recalled.
All right, well, sometimes I think my 9-iron's a 6-iron, my 6-iron's a 9-iron, so okay, I'll recall the capias.
Thank you, Your
Y'all
Honor.
work on and get it resolved, okay?
We are, Judge. I believe we're getting
All
depositions
right,
set.
thank you.
Thank you.
Show up on time next time. Have someone else help you read that notice if you have dyslexia.
Judge, the next out of custody that I have on the docket this morning is Miss Cecily Austin. She is unfortunately not here today. We did get a note that she is in the hospital. We do have a resolution first for a deferred prosecution agreement as well as for her to
All
resolve her
right, I'll
view.
recall a capias.
There's not a capias, Judge. Thank you for that.
There's not?
There's not already a capias.
Oh, she's not here.
She's just not here. She's in the
Oh, she's in
hospital,
the hospital,
Judge.
okay. All right.
We're working, if the court has no objection, we'd like to have her appear by Zoom today so that she can at least appear to at least enter her pleas for the VOP as well as get the deferred prosecution
Today?
agreement. Yes, Judge.
No. Where's she at?
She's in North Okaloosa Medical Center,
Well,
Judge.
we'll just set her when she gets out.
Okay.
I can't take a plea by Zoom. I mean,
The next available date
guess
that
I
we
could, but, you know, she needs to be fingerprinted and all that kind of stuff.
The next available date that we have, Judge, is 5/28.
All right, that's good.
That's fine with me, Judge.
Okay.
All right. Thank you, Judge. The next I have, Judge, is Mr. John Blaylock.
John Blaylock.
Your Honor, Mr. Blaylock is actually on, I believe, this afternoon's docket in 24 CF 722, but we have reached an agreement, and he's here this morning.
John Cody Blaylock. And that is 24 CF 722. And is he going to be entering a plea?
Yes, Judge, we're just getting that written plea agreement.
All right, Mr. Blaylock, would you please raise your right hand to be sworn? You swear the testimony you give before this court's true, so help you God? All right, thank you. Ms. Hall, are you here for another case? Pardon?
Dismiss the felony.
No.
Sign right there for me, please.
Sorry, Judge.
Oh, yeah, she can go? She
Yes,
pretty-
yes.
Let me see you up here real quick for a second.
Ms. Hall?
Yeah. Well, you can come up too.
Me?
Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
I may approach, Your Honor.
Okay, let's see. The state is going to agree to dismiss count 1, correct?
Yes, Your Honor.
And so you want to, Mr. Blaylock, enter a no contest plea to resisting an officer without violence, correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea? Anyone forced you or threatened you to enter this plea? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs done for you on your case? Court finds the plea is freely and voluntarily entered. Court accepts it, sentences you to 11 months, 29 days probation, $50 cost of prosecution, $220 court costs, $100 PD fee. Have a substance abuse evaluation with any recommended follow-up treatment. And you are currently attending Pattison Professional Counseling, which I would, are you asking that be considered your treatment?
Yes, Your Honor, they do court-ordered programs as well.
Okay, well, that will count for,
Doing Zoom counseling, then with Family First counseling as well.
Zoom and Family First.
He can give all that information to probation so
All
they
right,
can.
I'll allow him to do that. Continue with what it is and it counts towards your substance abuse evaluation, okay? Okay.
Thank you, Your Honor.
All right, thank you.
Just the probation so you can get some.
Yes, thank you. What's y'all's name?
Your Honor, next out of custody, I have Mr. Jacob Grice. Your Honor, Mr. Grice is not on docket this morning. This is 22 CF 3177, 23 CF 1431. We are asking to recall Mr. Grice's capias. He was supposed to be in court as well on Monday and unfortunately was not here.
Why?
I was at work, Your Honor, and I thought it was the 9th. And when I got here, it was too late. Court was already over. I wrote you an apology letter for it.
He did also contact our office right after we adjourned on Monday.
Judge, on Monday, he tried to call the PD's office. It's just a coincidence that he called on the day. He was in court on I believe the 22nd of April, and he was told to be here on Monday.
Well, don't mess up again.
Yes, sir, I won't.
Okay.
Judge, we last leave this set for pretrial 624.
Yeah, make sure you get your dates right, okay?
Call me. Call me ahead of time. Call me today to set up an appointment and keep it. Call me now. Call my office to set up an appointment. 624 is your next court date.
6/24, that's June 24th, okay? All right.
What about that, Your Honor?
Judge, the only other out of custody that I had was Miss Yupashishe Burgess.
Yes, ma'am, please.
Burgess.
She is present and approaching, Judge. We do have an agreement. I just need her to sign that, Judge. Going in now? You're all ready to go? Yes, ma'am. All that time counts. Yes, ma'am. So, that's what you'd like to do. Just sign it right there for me, please. Today's date, please.
Burgess, do you have any other shoes than happy face bedroom slippers?
Your Honor, she's going into a jail sentence today,
Okay. Probably ought to wear something different the next time you're in court.
She's happy about your services, Mr. Gibbs.
Thank you, sir.
If I may approach, Your Honor.
The jail slippers that I remember when I was in the public defenders was they looked like orange or yellow bananas that you stuck your foot in, and there was a happy face on those. So maybe that'll be okay. So, all right. Ms. Bird, this is State of Florida versus Yupa Cici, Adriana Burgess, 23 CF 2239. Ms. Burgess, you want to enter a no contest plea to the charge of possession of a controlled substance, a third-degree felony, and possession of marijuana, possession of paraphernalia, first-degree misdemeanor, correct?
Just
Yes, sir. Yes, sir.
Did I swear her in?
I am not sure. Let's swear her in
Ms.
to be sure,
Burgess,
Judge.
did I swear you in? Would you raise your right hand to be sworn? You swear the testimony you give before this court's true, so help you God? All right, you want to enter a no contest plea to those charges I just announced, correct? Talk up a little bit. Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it, sends you 30 days county jail concurrent. Starting today, credit for time served, $100 cost of prosecution, $550 court costs, $150 PD fee, all due within 180 days or go to a judgment. How many days credit she got?
Just a couple, Judge, I believe.
Well, you'll be out by the end of this month.
Should be.
Okay, thank you.
So he's going to fingerprint you and take you, okay? Judge, I think that's all the out of custody I have.
Okay. Ms. Rivers, you want to do something?
Yes, Your Honor. The first one I have is Dylan Sherman, 24 CF 725. Your Honor, he's going to enter into a pretrial intervention agreement.
I need to, is it a plea or
Yes,
just?
Your Honor. PTI.
All right, Mr. Sherman, please raise your right hand to be sworn. You swear the testimony you give before this court is true, so help you God.
Yes, sir.
This is 24 CF 725. You want to enter this pretrial intervention agreement with the state,
Yes, sir.
and you are entering a no contest plea to the charge of possession of more than 20 grams of cannabis, a third-degree felony, and possession of paraphernalia, first-degree misdemeanor. You understand that?
Yes, sir.
You aware of the rights you're waiving by entering this plea?
Yes, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Anyone force you or threaten you to enter this plea?
Yes, sir.
Are you happy with the work Ms. Rivers done for you on your case?
Yes, sir.
You understand you have 18 months to do the things in this agreement, and then the charges will be dropped, correct?
Yes, sir.
Okay, so, but if you don't do them, then I'm going to have to sentence you, or another judge will sentence you to what you agreed to be sentenced to. You understand that?
Yes, sir.
Okay. All right, well, get those done so you can get these charges dropped, okay?
Yes, sir. Thank you, sir.
All right, thank you.
Your Honor, the next one I have is Tanya Sullivan. She's before the court on 18 CF 2664, 19 CF 2472. Your Honor, I'm going to ask to continue it to a June court date. I've asked her to meet with the local probation officer because she was on probation in Alabama, and I did send an email to the probation officer, and we'll see if we can get a couple of things straight. So I've just asked it to continue it at this time.
No objection.
All right, when?
Do you have a June date?
Well, you want a miscellaneous June date?
Yes, Your Honor.
Like what, June 6th?
That'd be fine, Your Honor.
That's fine.
Okay.
Thank you.
Thank you.
What about Mr. Williams? You
I
got
think
some
that's
out
all
of
I have.
custody?
Judge, I have only one, and he's actually in custody, just not in our facility. That's going to be Bradford Henderson, 24 CF 97. I have confirmed, and I'll give the state a copy of the jail view from Santa Rosa. He's in the Santa Rosa County Jail on simple charges, actually.
For this case?
Yeah, it's a felony driving while license suspended. Judge, what I'm going to suggest that we do is just have me pass him on the docket. Looks like I'll just continue to monitor that case over there. I have been in contact with his public defender over there. Once he gets that case resolved, we can bring him back, try to resolve our case in a similar fashion. You know, if he winds up on probation, we don't want to send him to prison. If he winds up going to prison, we don't want to put him on probation. It'll help to know what they do over there.
So when do you want it? June 24th?
That's, well, yeah, that'd be fine, Judge. It looks like this is a new law violation, not a VOP.
All right, next case.
Judge, I have two cases of people that are not in jail, but they're on the call list for trials. We passed them to go out. One individual, the court waived his appearance because he's up in Birmingham, so I think we're just waiting to see if a slot opens up for that one. The other one is Ms. Lige. I have spoken with Ms. Lige. I expect that she's going to be here, but I have not seen her yet this morning.
Ms. Lige, for a trial?
Desiree? Judge, I think she was set, this was her drop-dead day on a plea. I did meet with her. She has advised me that she's has a Social Security case where they have ordered her evaluated and asked me to have another evaluation done on her. The evaluation we had would be somewhat stale at this point. We have tried to get a copy of that evaluation, and I think my secretary's confirmed that one exists. But we don't have a copy of it. And my understanding is that we're going to authorize another evaluation on her just to be sure that there's not a competency issue.
I don't have her name down as one going to trial.
I don't know that she was, Judge. I think the state and I were trying to resolve it for a non-incarcerative sentence. At this point, though, I can't represent to the court that it is resolved that way. What I'd ask to do is just leave it on for the 24th, and then I'll keep an eye out for her in case she does show up
Judge,
today.
here she is.
Oh, okay. Desiree? Hey, we're talking about you. Come on up.
I don't have her down as for a trial.
Yes, sir. She was set today, I think, as her drop-dead date on a plea offer that the state had made. It might have been also try to work her in if something had gone away. But at this point, I think I'm going to wind up asking my boss to have her evaluated again based on what she's telling me about Social Security and their evaluation.
There needs to be an evaluation done that does change.
So you want to extend that offer for till she gets this evaluation?
I believe it's an appropriate offer, so yes, Your Honor, we would.
All right.
Judge, we'd appreciate it.
Till when?
All right,
June-
Judge,
June
I'm going to say just to kind of keep an eye on things, let's go ahead and just leave it for the 24th. Maybe by then we'll have the evaluation back, and if so, we can figure out where we are.
All right, well, send me an order. Y'all send me an order on this.
Just an order continuing the case?
Well, I mean, doesn't she need to be, who's going to evaluate her?
We will pay for the evaluation, and I don't know if we're going to use Dr. McDonald or Dr. Zeman. It's going to depend on who we think can see her first.
Send me that, put that in the order.
Yes, sir. Okay.
All right, thank you. Ms. Rivers?
Yes, sir. Absolutely. Your Honor, this is Joshua Ramsey. He has a 1:30 court appearance for arraignment on 24 CF 781 possession. We would enter a not guilty plea at this time, request trial by jury, have pretrial conference date of 6/24 if the court so inclined.
All right, Mr. Ramsey, you're charged with possession of cocaine, third-degree felony, and we'll set you for June 24th. Court appoints public defender. She's pled you not guilty. Thank you.
Your Honor, this is Lydia Odom. She's before the court on 21 CF 2030 for violation of probation. We're going to enter a denial at this time and request.
All right, what's that VOP court date? May 20, June, when's our VOP court date in June?
Your Honor, you had said 6/6 on another case.
All right, June 6th.
No objection.
Thank you.
Come out and talk to you some more.
Parkinson?
Parkinson.
Should be the next one or close there too, Your Honor.
Okay.
And this is Adam Dale Parkinson. It's 17 CF 3022. If we could have him put on the June 6th.
All right, VOP arraignment, June 6th. Thank you. Thank you, sir.
All right. Your Honor, this is Seth Talbot. He's before the court on 23 CF 38, 21 CF 2077, 20 CF 2428 on a violation of probation. I believe we've reached an agreement in this matter, if I may approach.
All right, Mr. Talbot, would you please raise your right hand and be sworn? You swear the testimony you give for this court is the truth, so help you God? You swear to tell the truth?
Yes, sir.
Okay. This is State of Florida versus Seth Dwayne Talbot, 23 CF 38, 21 CF 2077, 20 CF 2428. Mr. Talbot, you want to admit that you violated probation? Did you read and sign this plea and sentencing agreement form? Are you aware of the rights you're waiving by entering this plea? Has anyone forced you or threatened you to enter this plea? Are you happy with the work Ms. Rivers has done for you on your case?
Yes, sir, I am.
Court finds the plea is freely and voluntarily entered. Court accepts it. Judge you guilty. Sent you 11 months, 29 days in Okaloosa County Jail. Credit beginning at the date of his last arrest, which is October 28, 2023. Followed by 1 year probation, continuing with ECLC. $100 cost of prosecution in each case, $100 PD fee in each case, $50 app fee, and 23 CF 38 waived cost of supervision. As this county jail time concurrent with each case number?
Yes, Your Honor.
All right, concurrent with each case.
And Your Honor, if you could, look at the date that the state attorney signed the plea agreement. She forgot when she had signed it.
No, Your Honor, I don't need that.
Well, I'm not sure what date this is. I think it's 4/22/24.
Thank you, Your Honor.
Thank you.
It's written in Italian.
The numbers, yeah.
That's an Italian signature, I guarantee. So, okay. So that's what it is. Okay, thank you.
Thank you.
And Your Honor, we're revoking the old probation.
Yeah, we're revoke the old termination.
Waiving the probation when he comes out of, waiving the probationary fee when he comes out of jail, correct?
Yes.
Yeah.
Your Honor, this is Richard Wagner. He's before the court on 23 CF 2526 for a bond hearing. Your Honor, his bond was previously revoked after he was arrested on 24 MM 1526, a misdemeanor. Mr. Wagner is a lifelong resident here of Okaloosa County. He has family ties to the community. He lives here. He works here. He has made his previous court appearances. He's asking the court to reinstate his previously posted bond. He's trying to prevent from losing his truck and his home, and he asked the court to reinstate his previous bond or set a new reasonable bond.
How much was it?
How much was your bond?
$1,250. Oh, yeah. What was the bond? I paid the bondsman $1,250.
So it would have been what, 12,500?
Possible.
What's the state say?
Your Honor, this bond was rightfully revoked because he committed a misdemeanor. He was arrested while he was out on bond. He's charged presently with possession of firearm by convicted felon. The evidence in the case is very strong against the defendant. The weapons were found in a toolbox, and the keys to the toolbox were in the defendant's pocket. He pled to the misdemeanor case that had revoked his bond, and he admitted that he broke the law while he was out on bond. He has a prior record that includes violent offenses such as aggravated assault with a deadly weapon, aggravated battery with great bodily harm. He scores right now 25.65 months DOC. He had a 12-1 DOC offer, which he rejected, and now the new offer would be for 26 months DOC.
What sentence did he get on the misdemeanor case?
Got, I think, credit for time served and cost of court.
And that new misdemeanor case was what?
It was driving on suspended license and possession. I drove someone up the road. I didn't know my license was suspended, and there was a pipe in the car that they didn't own up to, which wasn't mine.
And where do you work?
I work for myself. I work for James Cox Construction. I sub out work. I'm a carpenter.
Well, how about an ankle monitor if I reinstate bond?
At $1 a day, Your Honor?
Prior to his release, Your Honor. Thank you.
Your Honor, he's asking, would it be possible to do an ROR or signature bond with an ankle monitor?
10,000 signature bond with an ankle monitor.
At $1 a day, Your Honor?
May I ask, Your Honor, pre-trial services with weekly in-person check-in and random urinalysis?
Yeah, random UAs and pretrial services check in weekly, once a week. So you can sign yourself out. You got an ankle monitor, but Don't mess up, or I probably won't be inclined to let you out
I
again.
completely understand, sir, and I have a question. The ankle monitor, is it house arrest?
No.
Okay.
You go to work, it's to keep track of you, so, because you're looking at possibly going to prison, and, you know, we need to, if you cut that ankle monitor or whatever, you're gonna go right back. It's not gonna, you're gonna turn it into a much worse situation.
You
which-
don't have to worry about that with me, sir.
Yeah, the ankle monitor, just so they can keep up with you where you're at.
That's fine.
Kind of like in jail, but outside jail. Okay,
That's completely fine with me.
all right.
Thank you.
Have a good day. Have a good day, sir.
The ankle monitor's gotta be attached before he's released.
Yes, Your Honor. And that was $1 a day?
Yeah.
Yes.
Kilburn.
Charles Russell, Public Defender's Office. Judge, this is Daniel Kilburn. Case numbers are 17 CF
Yeah.
3565 and 21 CF 452. May we approach, Your Honor?
You want this off the record or on the record?
You can do it on record.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
boys, let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us.
You want to, Mr. Russell, you wanted to continue, Mr. Kilburn, some critical witness for your
Yes.
side?
Yes, sir. One of our witnesses that is unavailable, so we're asking for the next pretrial conference, which is June 24th.
All right, June 24th.
And we're also asking for a case management conference on May the 30th at 9. Between now and then, I'm going to make sure that none of my witnesses have anything scheduled, and hopefully we can hard set this thing.
All right, okay, thank you.
Thank you. Your Honor, Tim Gibbs on behalf of James Allen, Judge. This is 23 CF 2644, 24 CF 373, 24 CF 374, 24 CF 375. Judge, we had set him on today's docket to try to, he had a new offer that we discussed.
Yeah.
Today, we'd like to, he wants to decline that offer. We can leave this set for pretrial and continue to try to negotiate out a case. I believe we also have depositions being set on this one as well.
Okay, good, June 24th, hopefully you can get it resolved, thank you.
Yes, thank you. Your Honor, Tim Gibbs on behalf of Amber Barrow. Judge, this is 22 CF 2602. We have reached an agreement, if I may approach.
Ms. Barrow, would you please raise your right hand to be sworn? You swear the testimony you give for this court is true, so help you God?
Yes, sir.
This is State of Florida versus Amber Nicole Barrow, 22 CF 2602. You want to admit that you violated probation, is that correct?
Yes,
Did you
sir.
read and sign his plea and sentencing agreement form?
Yes, sir.
You wear the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Court are you happy with the work Mr. Gibbs has done for you?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it, revokes and terminates probation, sentences you to 11 months, 29 days, Okaloosa County Jail, credit for time served, $100 cost prosecution, $150 PD fee, all to collections. Adjudicated guilty. Thank you.
Thank
Can I
you,
approach Judge on the score sheet?
I'm good.
Yeah, here. You just go finger punch.
Ms. Boardman.
Your Honor, Tim Gibbs on behalf of Wendy Boardman. Judge, this is 22 CF 1407. She's recently come back from the state hospital. I'd like to leave her set for May 28th, so we can determine if we need any other evaluations, and we can try to get this.
Okay, May 28th, thank you.
So I'll come see you. Your Honor, Tim Gibbs on behalf of Isaac Calbo. This is 24 CF 529. Judge, we're here for a bond hearing. Motion to reduce or modify Mr. Calbo's bond. He currently has 10 counts of possession of child pornography, 10,000 each count for a total of $100,000 cash professional. He's unable to make that. We are requesting either to reduce the amount to $1,000 cash professional for each count for a total of $10,000, or to reduce it to a signature bond. He's unable to make the current bond that he has, Judge. Purpose of bond, of course, is to ensure his appearance in court. He does live locally. He has ties to the community. He's actually, or at least was, a manager at Brooklyn Pizza here locally. He had been there for quite some time. He does have a 2-year-old daughter who will soon be 3 years old, living at that. He does, I believe, have joint custody over with the mother of the child. That, of course, I'm imagining is perhaps going through the court system. So, Judge, we are asking to reduce his bond so that he can actually make that bond. He will be staying here locally, and I have no concern that he will miss court.
She was actually originally charged with just 5 counts of child sexual abuse material. He was given a $20,000 cash professional bond per count for his appearances in that paperwork. We reviewed the case. The CSAM that was found on his phone was enhanceable because it featured videos, bondage, children being penetrated. So we enhanced those to second-degree felonies and added another 5 counts. So we do believe the bond is appropriate as set. However, there is 5 counts that now need to be set with a bond, period, because he was just given the $20,000 per count at first appearances. His criminal history indicates he hasn't complied previously with legal orders. He does have 2 priors for resisting without violence, 1 disorderly conduct, and 1 willful violation of pretrial release. Also has priors for drugs, paraphernalia, and marijuana. He was previously ordered to be on pretrial with no internet-capable devices, not be within 1,000 feet of a school or where minors congregate, and no unsupervised contact with minors. We would also request GPS.
We have no objection to pretrial supervision conditions, Judge. The state brought up his criminal history. It looks like the last time that we represented him was in 2017, and in fact, the only times that we've represented him previously were misdemeanor cases. As she mentioned, possession of paraphernalia, possession of marijuana were some of his priors, violation of pretrial release. Additionally, Judge, the information that law enforcement gathered was from a search warrant that apparently has been sealed. Now, I know that we are working on trying to get that unsealed. I've spoken with Ms. Berrickman about that, to get that search warrant unsealed, but it honestly kind of terrifies me in the sense of a Brady violation, that something that is being used to charge a defendant is unable to be seen by that defendant. So we are working on that. I have nothing against Ms. Berrickman on that, but we are working on that.
And if I could speak to that, that's fairly routine in these cases.
Understood. It's nothing against Ms. Berrickman. We are working on that.
So,
Yeah, we are working on that.
but what was the situation with his child?
Judge, he does have a 2-year-old daughter. The mother also lives locally as well. His daughter, soon to be 3, they do share custody, I believe, is how that arrangement
I heard
works.
something about no contact with children or something. What was that all about?
I believe the request from the state was no unsupervised contact with minors. Is that correct?
Yes, that would include his own child.
And that's no objection.
All right, 1,000 cash or professional on each. And the monitor, $1 a day. No unsupervised contact with his child or any children. And what else was it?
Pretrial supervision, no internet-capable devices, not be within 1,000 feet of a school or where minors congregate.
Yeah, all that. Okay, don't mess up. Okay.
Call me when you get home.
Set
Thank you, Your
him
Honor.
for what, June 24th?
June 24th, Your Honor.
Okay.
Your Honor, Tim Gibbs on behalf of Mr. Wayne Diggs. Judge, this is 20 CF 2011. Your Honor, he has a violation of probation based on new charges out of Georgia. I thought I had filed a motion to reduce to set a bond for him yesterday. We had previously set him for this court date for a bond motion. I did file that bond motion this morning. Judge, we're essentially requesting a $2,000 cash professional bond. He's already bonded out in Georgia, waiting. They are essentially waiting to see what we do here with the charges before they proceed. I do recognize that according to the score sheet, he scores just under 14 months on this case. The allegations on the VOP, Judge, are based out of the Georgia charges involving possession of marijuana, possession of a firearm, possession of a controlled substance with intent to sell, manufacture, or deliver. However, he will be living in Atlanta. He does have family and friends here that are in the audience that are supporting here today, so I don't have any concern that he is going to run. In fact, he's completed probation in Atlanta several times before.
Is the bond, if I said it, you want 2,000 cash per?
Yes, Your Honor.
Is that going to let him relocate?
That's going to let him be in Atlanta to face the charges there.
Bill?
Yes.
I don't think.
No, I'm not aware of this motion. As he said, he didn't
It wasn't
file.
filed until just this morning.
So I have no way to even verify whatever statement he's making about the other probation. It's all new to me, so.
Bring him back this afternoon.
Okay.
Your Honor, can I speak, sir?
We'll hit here with this afternoon.
I'm going to let you talk this afternoon if you need to, okay?
We'll be
Bring you
back
back this afternoon so that
Okay.
she can check on whatever it is she needs to check on.
Yes, sir.
Okay.
We'll come back this afternoon. Tim Gibbs on behalf of Jamarcus Dozier, Your Honor, this is 20 CF 333. I believe this is VOP arraignment, Judge, but I'm not sure if we ever received any offers from the state on this one.
So the allegation is that he absconded, so we're going to ask for 12-1 DOC.
Is he on for this afternoon?
He may be, Judge, I'm not sure.
I can't seem to find him on any docket. What was his, Dozier?
Dozier, Your Honor. Your Honor, we'll enter a denial and leave, if we could just reset this to May 28th.
All right.
That we would ask to set the VOP evidentiary hearing.
No objection.
When?
5/28.
That's
Okay,
fine.
all right. I can't seem to find Mr. Dozier on my docket, but. All right, 5:20, oh, yeah, 5:28.
Yep, I believe he was number 21 on the docket, Judge,
21?
on this morning's docket. I'll try to get with the Alabama.
Oh, yeah, okay.
Thank you, Judge.
Jamarcus Dozier. William Flanagan.
Your Honor, Tim Gibbs on behalf of Mr. William Flanagan. Judge, this is 23 CF 2730. We had set Mr. Flanagan today because we had previously filed a report from Dr. Zeman recommending that Mr. Flanagan be found not competent. We were waiting to see the state's position if they wanted to get another evaluation. I don't know what the state's position is at this point.
We're going to ask for another evaluation, Judge. Specifically, Dr. McDonald is what we're going to ask for.
All right, send me an order.
I do want to put on the record that Dr. McDonald has contacted our office and says that she's currently not accepting any new referrals through the month of May due to her volume of cases that she's working on. I don't have any objection to her, and obviously in general, but I did want to put that on the record that she is not currently accepting new referrals.
Who are we going to send him to?
If the state would like another eval, they have a choice of doctor. I'm just letting the court know that that's what Dr. McDonald said. I don't have an
All right.
objection to Dr.
Okay.
McDonald.
Well, send me a name on the list.
We're still going to ask for Dr. McDonald. My understanding is that she's not accepting referrals for this month, but, next month is a possibility.
Well, send me a order.
Quite a ways away, but okay. Very well. 624, Judge.
Yeah. Next.
Well, there's another evaluation.
Yes, sir. Yes, sir.
No.
You're just going to have to wait for that evaluation.
All right. Kelvin Ford.
Your Honor, Tim Gibbs on behalf of Kelvin Ford. Judge, this is 24 CF 765, 24 CF 766. Judge, we're here for a motion to reduce or modify Mr. Ford's bond. Judge, he's currently charged with, I believe, burglary of a conveyance, as well as grand theft auto, as well as on the first case, on another case, allegations of possession of controlled substance and trafficking. Judge, his total bond is $127,500. Cash or professional, he is unable to make that bond. He's unable to make any bond. However, he is amenable to pretrial supervision with GPS at no more than $1 per day. He has lived in the area for life. He would be living here in Crestview locally. He has 2 children. One of them is 7 years old. He's only gotten through 9th grade, I believe, in high school. I don't believe he has any failures to appear. We're asking the court to enter a signature bond for Mr. Ford so that he can actually bond out.
What's the state say?
State objects, Your Honor. He's charged with trafficking in amphetamine, first-degree felony, where he's facing a 3-year minimum mandatory, burglary of occupied conveyance, and grand theft of a motor vehicle. He was arrested early in January of this year for possession of controlled substance and paraphernalia, and the state offered him a deal to dismiss the felony in exchange for a plea to the misdemeanor possession of paraphernalia for time served. The same day that he pled on that felony case, he committed a burglary when he went to the victim's home, entered the victim's car while the victim's daughter was sitting in the back, and he put it in reverse trying to leave. Fortunately, the mom, the victim, showed up and yelled at him, so she was able to stop him, and he ran away. When he was arrested for the warrant on that burglary case, he was found to have 14 grams of methamphetamine on his person. So
This was the day that he just got sentenced on that deal?
Yes, Your Honor.
I'll leave the bond the way it is.
Thank you.
Judge, we don't have FDLE on the substances, so we don't know how much it is.
The way it is at this
Very well.
time. Maybe you can work it out. I don't know.
We'll
But
try.
if you pick up a new charge on the day you get out, I mean,
the judge, and I was on bond with Helen Bird, and I came to court, and you dismissed the charge, and I was on bond. I didn't never.
I'm sorry, could you place him under oath if he needs to make statements?
all right, Mr. Ford, would you raise your right hand to be sworn? You swear the testimony you give before this court is true, so help you God.
Yes, sir.
Okay.
Put your hand down.
Mr. Gibbs?
What would you like to share with the court?
I would
Mr.
like to
Ford?
share with the court that Mr. Gontier, he knows that when I bonded,
Gontier, sorry.
Mr. Judge Gontier, when I was on bond, I bonded out. Miss Helen Bird came and got me, and I came to court, and I was going to court for that charge. And when I came to court, because the vehicle that I was riding in was not my vessel that I was not in. I was a passenger of that vessel, and they arrested me because he tried to grab me, saying I was just resisting, but I didn't resist nothing. I let him arrest me, and I came to court on bond.
Is that the case that you pled out earlier this year?
Yeah, but I never had no burglary of nothing. I don't even know who the victim is, nothing. I'm trying to put on my behalf that I don't know nothing about this and what she's saying and what he came to talk to me about a warrant, what they're saying. And, Your Honor, they're saying that I was trafficking and saying I have no knowledge of no drugs. There is no drugs. If you raise my arrest report, it says...
We're not trying that case right now. But
I understand, but I'm telling you that when she says something about trafficking, there is no drugs in my possession coming off my possession. I don't even know what they're talking about.
Again, Judge, we don't have FTLE yet, but...
Well, what do we, I mean...
And I'm trying...
When I sentenced him, you're telling me he went out and picked up a new charge, right, that day?
So
The same day, on 2/8. Yes, Your Honor. There is court record when he entered the plea.
A warrant was put out, Judge, based on the allegations from the alleged victim in that case of the burglary and the grand theft auto. She apparently identified him through a Facebook post or picture that he had allegedly posted. I haven't seen that yet. I don't know if it should be coming in
Was
discovery.
it some prior alleged incident, or did he get sentenced, went out somewhere, and allegedly committed a new crime?
That's correct, Your Honor.
That's the allegation, Judge, is that after he was sentenced, he committed these new charges.
After he was sentenced,
After he had a time-served sentence, Judge.
after I sentenced him, after I dismissed the charge, he supposedly went out and committed a new crime?
Allegedly, Your Honor.
As I said, supposedly, allegedly. I'm gonna leave it the same without prejudice. You can bring it up at some other future date. Check into all this.
We'll work on it, Judge.
Yeah, check into this. Maybe I'll reconsider. But he says he's.
We'll see what the discovery process brings up.
That's it. At this time, check into it and see what we got.
I don't want to motion and everything. Matter of fact, I want to put in for a speedy trial, too.
We'll talk about it. We'll talk about it. Your Honor, Tim Gibbs on behalf of Allie Fowler. Judge, she is here this morning on 23 CF 656 and 22 CF 188. She also has 24 CF 767. I believe that's set for this afternoon.
This is set for this afternoon, too?
Judge, yes, she's also on the plea day docket for this afternoon. We'll enter denials and not guilties all around for today. I believe drug court is also looking into her. I've negotiated with Mr. Sprouse about a potential deal today, but drug court, I believe, has also showed an interest in her. We'd like to explore that route as well, if we could leave her set for 528 without subpoenas.
All right, move it up if you can get it all figured out.
If we get it wrapped up, Judge, yes.
Okay.
That's without subpoenas?
Without subpoenas for now, and then we'll go
That's
from there.
Allie Marie Fowler?
Yes, Your Honor.
Okay.
So, yeah, we'll see about drug court. Terry will get in touch with me. I'll get That's your copy for the new charges.
Okay, next.
I think that's all of my morning inmates. That's my morning docket. Thank you.
Wilt Williams?
Yes, sir.
I've got from Mr. Williams is
I sent an email over yesterday. You guys consider reinstatement on him?
No, I'm asking for 10 days, Okaloosa County Jail. It's either that or go back on probation and then come back later.
You're asking for 10 days?
Yes.
Judge will do that.
I can't find him on the docket.
I'm sorry, Judge?
I don't have him on the docket.
Judge, I've got him at 32.
Number 32?
Yeah, on my copy, Judge.
Oh, okay. Thomas Haney.
Yes, sir.
Is that right? Okay.
Yes, sir.
Yeah. Okay, good.
Judge, he's willing to admit for 10 days. We can pass him for a few minutes and I can draft it up, or the court can do an oral.
All right,
It's a
Mr.
VOP,
Haney,
so.
would you please, this is 22 CF 2759 State versus Thomas Haney, violation of probation. Please raise your right hand to be sworn. You swear the testimony you give for this court is true, so help you God.
Yes, sir.
You want to admit that you violated probation?
Yes, sir.
Are you aware of the rights you're waiving by entering this admission?
Sir.
Has anyone forced you or threatened you to enter this admission?
No, sir.
Are you happy with the work Mr. Williams did for you on your case?
Yes, sir.
Court finds admission freely and voluntarily erring. Court accepts it. Sentence you to 10 days, Okaloosa County Jail. Is that, does this, and revoke and terminate his probation, or?
Yeah, it's my understanding. It's to be revoked.
Revoke and terminate his probation. Was a $100 VOP fee?
Judge, I believe it's $100 still cost of prosecution, and then a total of $150 to our office.
$100 cost of prosecution, $150 PD fee?
Yes, sir.
Okay. 10 days county jail, credit for time served. Does he serve time?
Yes, sir. That's my understanding. I spoke to him last night.
Is that right? Credit for time served?
Yes, Judge.
How much time have you served already?
You told me last night you had like 4 days.
Since the 20th.
And he's been in now since the 20th, so.
Since the 20th of April?
Yes, sir.
He'd probably get out today, wouldn't he?
I would think so, Judge, but I make it a practice of not estimating gain time
Yeah.
and stuff like that.
Well, you should be out. You'll be out before the next Super Bowl. How about that?
Yes, but thank you, sir.
Yeah, you'll be out. Okay, thank you.
Thank you, Judge.
10 days, county jail, credit for time served, revoke and terminate probation.
Ralph, so, yeah, you're good.
Anderson?
Come stand over on this side of me, Mr. Henderson. Judge, Mr. Henderson has a violation of probation. He's also scheduled for an arraignment this afternoon on a new law violation. I'll enter denial on the VOP, and if the court's prepared to arraign him on the new law violation. Do we have an information filed on that?
Which?
Which Mr. Henderson?
Oh, this would be Zachary. I thought we already did Bradford. I called him up with the not in jail because he's in Santa Rosa jail.
Yes, that information was filed on the new case.
Okay. Then I'll go ahead and arraign him on the new case as well, Judge. And that way he'll be done for the day.
Okay.
And our
All right,
plea of
this
not
is
guilty on
Zachary.
his behalf, 15 days pre-arraignment motions, trial by jury.
Zachary Joe Henderson, charged with aggravated battery on a law enforcement officer, pleads not guilty, correct, and appoint
That's
public
correct.
defender. Okay.
Thank you, Judge. Date on it, Madam Clerk?
We'll go June 24th on it.
Thank you, Judge.
Thanks.
All right, Mr. Henderson. And Judge, we'll just have the VOP come in with the other case.
Yeah.
Thank you, Judge. Okay. Just 1 second, Ms. Knight. All right, Judge, we're going to, let me ask you this. Do you have an offer on Ms. Knight for community control? Otherwise, I'll leave her on and try to get her in Phoenix House or something like that.
Yeah, negative. The offer is 1129 OCJ with ECLC.
ECLC is that program I talked with you about last.
And I get credit for all time, sir?
Yes, ma'am, you get
Okay,
credit.
yes, sir, I do it.
VOP.
This is the VOP, Judge.
All right, this is 22 CF 176, State of Florida versus Allison. Leah Ann Knight, is that right?
Yes,
Knight? Okay, would you please raise your right hand and be sworn? You swear the testimony you give before this court is true, so help you God.
Yes, sir.
You want to admit that you violated probation?
Yes, sir.
Are you aware of the rights you're waiving by entering this admission?
I do.
Anyone force you or threaten you to enter this admission?
Yes, sir.
Are you under the influence of any medication or drugs that prevent you
sir.
from knowing what you're doing here today?
Yes, I have my own recognizance.
You're what?
Yes, sir.
Okay, you happy with the work Mr. Williams done for you on your case?
Yes, sir.
Court finds admission freely and voluntarily entered. Court accepts it. Sentences her to, we're going to revoke and terminate probation?
Yes, sir.
Sentences her 11 months, 29 days, Okaloosa County Jail with the ECLC program, credit for time served, and...
$100 cost of prosecution, $150 PD.
Yeah, $100 cost of prosecution, $150 PD fee.
Okay, no problem.
How much time have you served?
I believe I have 3.5 months in from prior being there about 18 months ago and this incarceration.
How much on this one?
A month.
It's about 4.5 months.
Yes, sir.
Should be out around time for football kickoff. What?
We would ask that she gets credit for time served on just this charge. If she was in jail for other charges, that it shouldn't count.
Well, I would agree. I think what she's talking about is her initial arrest,
My initial arrest.
in which case
All
she
right,
would be entitled
yeah.
to that.
From her initial arrest on this case.
Yes, sir.
Okay.
All right, Judge, thank you.
All right. Yeah.
I've already paid my 615 supervision for
Okay.
community control. I paid all that stuff off.
All right, well, if there's nothing outstanding, then there won't be anything to send to collections.
Okay. All right.
Except potentially this. Yeah, I went over that with
So,
her last night as
sir,
well. I printed out.
I won't get the credit for the time I was here when I had my other charges. And
You get credit for Your time
Right.
on this case,
this case.
not other cases.
Okay, okay, I got it. Yes,
Okay.
sir.
Okay. Judge, this is a competency hearing. We have an evaluation. Short version is that Mr. Lanehart was determined to be incompetent but not qualify for involuntary commitment. I did reach out to Mr. Barnes because Mr. Barnes would do the conditional release plan on it. I've got a copy of the evaluation I can provide to the court. I think both sides stipulate.
What do you say, Ms. Basso?
Your Honor, the state has no objection to the court considering the evaluation as a basis for determination of competency. We have no reason to challenge the fact that he's been deemed incompetent at this time, and that he is available for restoration. I believe there is restricted means would be a conditional release plan. However, we do not have anything in place, and we would object to Mr. Lanehart being released without such a plan in place.
And I've explained that to Mr. Lanehart, and I've also explained to him that Mr. Barnes would actually draft the conditional release plan, typically would supervise him on it, and that he'd have to comply with Mr. Barnes's directions.
All right, well, how long, because sometimes, doesn't it take Mr. Barnes a little bit of time to get this done because he's
Sometimes it
overworked or
does.
something? He's overwhelmed, or?
Judge, if you want to pass him out, I can try to get a hold of Mr. Barnes. I don't see him in the courtroom. I can go up to his office over the break and see if I can get him back in for this afternoon.
Well, that's all right.
Or
We'll
we
just-
can set just a close date on it, and I'll notify Mr. Barnes that that's his date
why
to
don't
have
we-
the plan available.
Why don't we come up with,
When's our next miscellaneous date?
well, we got May 3rd or June 6th.
I'm going to ask May 30th, Judge. I'd like to keep him within a month, and he's at the jail. It's not like we've got to wait for him to come in and see
All
Mr.
right,
Barnes.
have something for Mr. Barnes May 30th so we can get him help. Or
Yes, sir.
Mr. Lanehart help. Court's reviewed this and find this evaluation by psychological associates, and that was Dr.
Now, if we get something quicker,
Yeah,
I'll contact
Zeman.
you about it. We can talk about it. Maybe we can just stipulate to it and submit an order. Oh, yeah.
Yeah. And so, yeah, he's not competent, but he lacks the ability to consult with his attorney and all that. But yeah. Yes, yes. Based on Dr. Zeman's report that I've reviewed.
Thank you, Judge.
That was, yeah.
Okay. And I'll go by and see Mr. Barnes. Or
Here's
make an
here's your,
appointment with him
Mr. Williams.
today. Yes, sir. Thank you. Judge, I can print out another copy of that if you need to put it in the court record.
I have an extra copy already.
All right, well, we got to get one in the court record. Okay. Yeah. I'm going to file it with the, you have any objection to file it with the court? I mean, the clerk?
We have no objection.
No, Judge, it just has to be under seal since it's a confidential record.
Yeah.
Thank you.
Yeah.
Judge, Ms. Oviedo's here on a violation.
Okay.
I did not have an offer in the file. If the state has one, we can advise her. Otherwise, I'll just enter it now.
It's a 12-1 DOC.
12-1 DOC. Let's enter a denial then at this point. That's not something that would get her out, so.
All right. What about when you want to go?
Judge, I guess we can try setting her on the 30th date.
All right,
and see
May
if we can get
30th,
it
maybe you
resolved.
can work it out.
Thank you, Judge. All right, so right now it's a state prison offer, but I'll come out and I'll talk with you again, and I'll see what I can work out, okay?
Thank you.
How much time has she got served?
Judge, I think she was out originally, so it'd be just since her arrest
Okay.
on this occasion. Yeah.
Robert Joseph Macri?
Yes, sir.
Okay. This is case 23 CF 1714.
Let me talk to
Yeah,
him
yeah,
about it.
yeah.
Originally, we were going to do,
Oh, that's the, no, but
yeah,
did
this
he
is the
plead to
one
the
that
other?
he's got a BOP.
Yeah, the misdemeanor. Right. Well, you talk to him, see what he wants to do.
Judge, we've got a change in the offer. It's now 1129 county jail with credit for time served.
Mr. Macri, you,
Would you go 9 months?
Well, he has already 10 months in. Yeah, that's fine, that's fine.
Just make it time served, Judge. That'll solve this end of the problem.
any objection to that? Let me sentence you to time served.
No, sir, not at all.
You
Credit
raise
for
your
all,
right- Okay, I think I swore you in.
credit for all time served?
That's what time served kind of means.
Oh, okay, so I'll get.
You
the
want to
9
enter a
months.
plea to violate, you want to admit that you violated probation?
Yes, sir.
Are you aware of the rights you're waiving by entering this admission?
Yes, sir.
Anyone force you or threaten you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Mr. Williams done for you on your case?
Yes, sir.
Sentence you to time served in county jail. Is there any cost?
$100 cost of prosecution, 150 PD fees.
150 PD fee, $100 cost of prosecution, go to judgment, and I guess you'll be released today,
Okay. Thank you.
okay?
Well, I don't know, he has a misdemeanor case. I don't know if he has a bond
Yeah,
on
he
that
has
one.
a
Well,
misdemeanor
you
case.
got some misdemeanor case, I don't know what the bond is on that.
And I had pulled his original and went over.
So
it
you're
with
still
him
be
last
held,
night.
I guess, on that misdemeanor case, I'm not sure what the bond is. I can't change another judge's bond.
And I explained to him, he actually was inquiring about pleading on the misdemeanor before, Your Honor, but I
Yeah.
explained to him that you don't have jurisdiction over a non-pendant misdemeanor, and the misdemeanor court doesn't have jurisdiction over felonies.
What judge is it in front of, on the misdemeanor?
Judge Ward.
Well, Judge Ward has court all the time, so you didn't get it.
And I've already emailed Charles Hall to try to get him in and get it resolved.
Yeah.
So this is. Thank you.
Next one, Amanda.
Yes, sir, Nadaros.
Amanda Nadaros.
Judge, we've got a negotiated plea in this case. If I can approach.
All right, Ms. Nadaros, would you please raise your right hand to be sworn? You swear the testimony you give before this court is true, so help you God?
Yes, sir.
This is State of Florida versus Amanda Nadaros, 21 CF 115. You want to admit that you violated probation?
Yes, sir.
You wear the rights you're waiving by entering this admission?
Yes, sir.
Anyone force you or threaten you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing
No,
what
sir.
you're doing? Are you happy with the work Mr. Williams done for you on your case?
Yes, sir.
Court finds admission freely and voluntarily entered. Court accepts it. Judge you guilty. You are to remain on probation, on drug offender probation with curfew. Enter the ECLC and comply with it. Adjudicated guilty. And I don't have a time on the curfew.
Judge, what I think normally what they do is 7 p.m. to 7 a.m. and then
Okay.
allow probation without leave of court to adjust that
All right,
to
that's
meet
what
a
it'll
work
be.
schedule.
7 p.m. to 7 a.m. and the probation can adjust it for jobs or some other situation.
All right, thank you very much, Judge.
All right.
Okay, ma'am. And Judge, that's all I have. I am pulling the pretrial detention duty this week.
Got one. There's a lady back there raising her hand. Well, who's that? What's your name? Jessica, is it Dunfield?
Duffield, yes, sir.
Duffield? Yeah. Why, you're here on a violation of probation. Is there an offer for Miss Duffield?
Yes, Judge. We can either modify the probation for her to complete her substance abuse evaluation and treatment, or she can do 6 months Okaloosa County Jail. She's got choices.
Your Honor, I completed my substance abuse evaluation already.
Probation, is that true?
I'll withdraw, recall the capias.
Your Honor, last time I was here, I had a Bridgeway appointment, and y'all set my court date for today, and I went to my Bridgeway appointment. There was no recommendations from Bridgeway for any substance evaluation classes or anything. My probation officer, Ms. Connolly, is aware of that.
Your Honor, if she can come back, since she was late anyway, at the 1 o'clock docket, I can get all that information and make sure.
All right, I think it's one.
It's 1:30, Your Honor.
1:30. Come back at 1:30, make sure, okay? They just
Yes,
want
Your
to check and make sure.
Yes, Your Honor, no
I'll
problem.
recall the capias, huh?
Is that all we're checking on to see if she completed that evaluation?
That's correct.
Okay.
And just for the defendant, if she hasn't sent the proof to probation, then she could do that in the meantime.
Sure. I'll try to obtain proof before 1:30.
All right, well, come back at 1:30 so we can make sure, okay?
Yes, Your Honor.
Okay, thank you. What else we got this morning?
Jason Kuntz, Judge, is one that was on the docket. It was going to be, it was set today. My understanding was that it was set today to see if a trial slot had opened up in the second week. Apparently, one has opened up on the Thursday of the second week, but talking with the state, they had filed a Williams Rule notice, and my understanding was that she was seeking to Williams Rule in the second case that goes. He's got two cases. The results in the first case, or the events in the first case, and that would be, of course, assuming that he was convicted in the first case. So I discussed that with him and explained to him what Williams Rule was and everything else. I'm learning today that no, she intends to Williams Rule the facts of the first case, or the facts of the, I guess, the second case in the first case for trial in that case. And there would not have been any kind of determination of his guilt as to those facts that they're going to Williams Rule in. My recollection of the case law is that they can't do that. So I would object, and there'd have to be a full-blown hearing. So I think we're just going to have to continue it out, Judge, and schedule a hearing on the
Is
Williams
this Jason Kuntz?
Yes, sir.
This is
It's
Jason Coons. My understanding is now we do have some time next week. We could have.
right, and that's what you and I discussed earlier, but I think we're going to have a full-blown hearing on the Williams Rule.
Right, I'm saying I think that there's time on the trial cycle now to have that hearing next week prior
Oh,
to trial.
okay.
The other thing I'd like to put on the record is defense did ask me to leave the offer open till today, so the offer is revoked today.
Yes, ma'am.
So in other words,
I think what we're talking about is leaving it on for Monday of the second week, and then between now and then, we can schedule what day we're going to have the Williams Rule hearing.
What days do we have available? I mean, I know we were going to discuss trials, so what do we have available that first week?
I mean, y'all think it's just so easy for me to just move these trials around, you know? Because I got trial admin I got to deal with, and, you know, we got other cases, and so I had him set for picking a jury on May 20th and trial on May 23rd.
Right.
So you're saying you still want to go to trial on pick a jury on May 20th and trial May 23rd, or continue everything?
I'd like to try and put the hearing next week in one of those gaps so that we are not pushing this out another cycle.
Okay, so do the hearing next week, but not necessarily the trial?
No, and then have the trial, pick the jury the following Monday as.
Well, I was going to try to move some of these cases, one or two of these cases, till next week. I mean, are we going to go to trial on these, Mr. Powell, Persley, Kuntz, and Arp?
Kuntz and ARP, yes, Your Honor.
Pardon?
Kuntz and ARP I can say yes on, and I do have an officer that's at training the first week, which is why I needed the second week. But I can do my hearing.
And so who's the defense attorneys on Powell and Persley?
Powell, Your Honor.
Yeah.
Firstly, is Mr. Hardy. However, Your Honor, I can just anticipate we were discussing an agreement, so I don't believe that case is going to go to trial.
Mr. who?
Mr. Hardy, Ryan Hardy.
Oh,
On
Hardy.
Persley, on defendant Persley.
Persley.
The first week.
So that would, okay, that would help if that case went away. So pick and go, if that goes away, then we have a trial on the 22nd, 23rd, and 24th, right, so far, right? If that one goes away, if Persley goes away, right?
Yes, sir.
I think that just clears up the.
Well, I need these jury instructions by next Thursday, you know how we do. And the latest information and a verdict and the preliminary jury instructions, not the voir dire ones, but the preliminary. So it looks like we'll probably have 1, 2, 3 trials next week. I mean, the 20th, right. And then we may have a Williams rule on Kuntz next week sometime, correct?
Yes, sir. I'll take a look at it and I'll file the objection, a written objection to it, Judge. Yeah, I'm fine with going ahead and picking a date to hear it. That's what I was
Was it
gonna
some
ask
type of
you to do.
substantive, I mean, some type of similar facts and to
he's
prove
got two-
motive or something, or?
Yes, Judge. This defendant has 2 cases. He was chatting with 2 different undercover officers.
Oh, I got it. Okay, I don't need to hear anymore.
We could also have any motions in limine heard at that time to make be given it's a pick and go.
Yeah. Okay, well, get with, get me a date. I'm happy to do it.
How does the 15th work for you?
The 15th? Is that next Wednesday?
Yes, Judge.
That's probably not a good day for me. Wednesdays are,
What about the 14th
What?
in the afternoon?
what day?
The 14th in the afternoon?
Yeah, we'll try that. That's a third Tuesday, right? So we'll try that one.
Like us here.
How long do you think it'll take?
Probably not more than a half an hour from the state for MIL and we.
We'll do 9 o'clock. How about that? Tell Miss Cheryl so I don't just go hang out at the donut shop thinking I don't have anything, because I like to stop by there in the morning to get me a donut to get energy to get going, so I can maintain my sweet disposition throughout the day.
Judge, I do have hotel reservations in New Orleans, but I'll see if I can cancel those. Not for the 14th, but for this weekend, so I can work on these over the course of the weekend.
You're not going to go to New Orleans because of this?
Well, it was supposed to be a family trip. The rest of the family bailed. I'd be going by myself, although I used to live there and, be visiting old haunts. So, but it'll be all right.
Best you stick around or you'll get in trouble.
Oh, no, Judge. I worked EMS there, so I still know most of the officers, and I'd swing by Central Lockup and post bond on my way in.
Okay. Well,
I don't get in trouble.
All right.
Not that kind of trouble, anyway.
And Mr. Williams, I just asked you if any MILs or anything else, you'd file it by end of day tomorrow, other than objections, so that we can.
Yes, ma'am.
All right, well, that sounds good, so we'll hear that. And then, so we have a detention hearing at 12:30, and then we have a 1:30. Then we have, we have a sentencing hearing at 2. And then,
Evidentiary.
I have 2 evidentiary hearings.
And I have one, Your Honor, with witnesses.
what time they start?
This were set at 2 p.m.
2?
Motion for statement of particulars on Mr. Austin. I believe that's with Ms. Merrifield, and that's, for the most part, worked itself out. We filed our response and amended our information. I believe she'll.
It looks like we cleared up a lot of 1:30, but we still have, are these, this is arraignment stuff, isn't it? Yeah.
The 1:30 is arraignment, 2 o'clock the motions. May I, Your Honor, bring something up? The pretrial detention hearing that we have with Ms. Flowers, she has sent an email to Ms. Gary and copied me on it, saying that she can either appear via Zoom or she wouldn't object to continuing the hearing to May 28th, when she can be present, because I've also extended an offer for a plea offer. And also, additionally, there is no prejudice to the defendant because he's a violent felony offender of special concern who's on probation, so she would have to be held without bond on the VOP anyway. Like, she wouldn't get out.
Would you send me an order on this and continue to May 28th?
To May 28th, yes, Your Honor.
Just get with Ms. Flowers.
I will respond to the email to Ms. Gary and Ms. Flowers saying that to
All
send an
right,
order.
So that takes care of the 12:30.
Yes, that takes care of that. So she doesn't need to be transported at 12:30.
Okay. Well, see, that's why I keep y'all around as my state attorney and public defenders, because y'all work hard, work together, work good.
Yes, Your Honor.
So, okay.
Judge, with that,
Otherwise,
do we
I'd
have
have
any
to
other?
get rid of you. Huh?
Do we have any other pretrial detentions for 12:30?
No, there was only one.
And Judge, I was slow on the draw on one of my score sheets. May I approve?
Yeah, slow on the draw. Don't ever say that. Just bring it. Just admit. Yeah.
Just bring
don't
it.
ever admit anything. That's what I used to tell my clients when I was a